Coming up next, Book TV presents Afterwards, an hour-long program where we invite guest hosts to interview authors. This week, author and judicial analyst Andrew Napolitano discusses his new book, Lies the Government Told You. In it, the former New Jersey judge argues that government officials have consistently violated the Constitution for years, with little protest from the public. He goes on to say that individual freedom is regularly violated by the state and that most Americans are too willing to look the other way. He debates his perspective with consumer advocate and three-time presidential candidate Ralph Nader.
The book is Lies the Government Told You, Myth, Power, and Deception in American History by Andrew P. Napolitano. And Mr. Napolitano is here to have a discussion which I think the audience is likely never to forget. This is a very powerful book. In a world of self-censorship, Mr. Napolitano does not self-censor. He graduated from Princeton University in 1972, Notre Dame Law School in 1975. And what have you been doing briefly since then?
Admiring your work, Ralph Nader. It's a pleasure to be here with
Thank you.
Absolutely. You and I met first when I was an undergraduate. You were a hero then, and you're a hero now. We're both graduates of the same wonderful educational institution. I practiced law for about 10 years in New Jersey, and then I was appointed to the bench by Governor Tom Kean. This is a trial court of general jurisdiction. So everything from jaywalking to serious crime, everything from slip and fall in a supermarket to serious economic causes of action. It's a full-time judgeship. You're appointed by the governor, confirmed by the Senate for 7 years. If reappointed and reconfirmed before the end of the 7, you have it for life. I was given my lifetime appointment by Governor Christine Todd Whitman. After about 8 years, I got a little bored and decided there were other things I wanted to do, and I returned to private practice. That was unusual because people usually don't leave life-tenured judgeships. After just a couple of weeks in private practice, I was approached by the then president of CNBC, who said, you know, we're about to cover this trial in California. It's a little crazy. The judge is a little off the wall. I thought maybe I'll put an ex-judge on the air to second-guess the trial judge in this case. Have you ever heard of him? His name is Lance Ito. So I covered for CNBC the O.J. Simpson trial for 4 or 5 days a week for 13 months, at the end of which we all know the outcome. At that time, MSNBC was formed. The president of CNBC, who had engaged me, founded Fox. That was Roger Ailes. And so Roger was kind enough to bring many of us who had worked for him at CNBC over to Fox, so I was there almost at the very beginning. I was practicing law while doing all this. I've been at Fox since 1998, full-time since 2001.
And now you're starting a new program on libertarian programs, it's called in the New York Times.
I am.
On weekends.
I am. It's called Freedom Watch. We tape it on Thursday mornings. It runs 4 times on weekends. And it is dedicated to the proposition that the individual has certain natural rights, which the government can't take away, absent a jury trial for violating somebody else's natural rights. It's dedicated to the belief that the free market is indispensable to human prosperity, to the belief that the people have the right to have a government that stays within the confines of the Constitution, and much of what the government does is outside those confines. I am a night watchman, and my job is to watch the government and report when it takes freedom and property.
All right, now let's get into this book. This is your 5th book on the Constitution. You've written. You're very serious on it being safeguarded and applied. And I want to read exactly how you define lies, because this is very important. You're not just talking about myths, you're not talking about false statements, you're talking about lies. And in your book, you define it this way, quote, truth is identity between intellect and reality. A lie is a knowing and intentional violation of the truth. The difference between the two often depends on whether one is in the governing class or the governed class. Now, here's how you apply it, starting early in American history. And this is the kind of party line that really is taught to millions of school children. And you don't mince words. Here's what you say, quote, Would Americans have reelected Franklin Delano Roosevelt had they known that he caused the attack on Pearl Harbor? Would voters have chosen Lyndon Baines Johnson, the supposed peace candidate in 1964, had they known he was secretly planning to ramp up the Vietnam War? Would George W. Bush have been reelected in 2004 if we knew he was illegally spying on us, concocting evidence for war, torturing people, and lying about it? End quote. Now, this shows you're nonpartisan, because you've got Democrat, Republican. And what you do in the book is basically describe the lies and give your evidence, and then you have footnotes throughout the book. So this is not like an offhand assertion. And so I want to go through a number of these lies. And the first one is every vote counts, lie 4. Every vote counts. And you really go after Bush versus Gore and other things. Would you explain why you think the statement, every vote counts, which is ingrained in our political consciousness, is a lie?
The Bush versus Gore case was a violation of federalism. It was the federal courts telling a state court system how to count its votes. It was an artificial endpoint. The Supreme Court said you can count the votes, but you got to stop in an hour and a half. The case came down at 10:30 at night. The deadline was midnight. It was a massive federal intrusion into an area reserved under the Constitution for the states. So it prevented every vote from counting. And it was a decision made by justices, some of whom are friends of mine, who had a political predilection in the direction that they want to go on both sides of it. They should have had nothing to do with it. The outcome should have been abided by the political machinery in Florida, whether that was the legislature or the Florida Supreme Court. But for the Supreme Court of the U.S. to jump in and on a party line vote say the end is now here, assaults the concept of representative democracy.
What should they have done?
Nothing. And decisions should have been made by the highest authorities in Florida, whether that was the legislature retroactively changing the law, as it was attempting to do by saying we're going to decide where the electoral votes go, or whether it was the Supreme Court of Florida saying to the legislature, you can't do that. Be patient. When they finish the recount, they'll tell us who won. But it was a Florida decision. The basis for the decision was equal protection. The basis for the decision was hanging chads count in some parts of Florida and they don't count in others. Equal protection has never been used by a federal court to regulate the manner in which votes have been counted. It was never intended to regulate that part of governmental behavior.
So this is really a political decision.
Absolutely.
5-4.
Absolutely. Absolutely. And the public did not get, probably, because we don't really even know what happened in Florida. There were a couple of subsequent recounts. We don't even know if the public got the person they voted for. We know they got the person who received millions of fewer popular votes, but through our constitutional system succeeded in and the Supreme Court's intervention succeeded in getting a majority of electoral votes.
In other words, what you're saying is Gore got 500,000 more votes than Bush, but the Electoral College threw it into Florida. And
that's the history.
Yeah. I know you use other cases to make the point, and you criticize Chief Justice Roberts, when he was up for the Senate for confirmation. He said judges are like umpires. They call balls and they call strikes.
You know, that was a great soundbite, and it probably deflected some criticism of him for people who feared he would be an activist, whichever way you want to go and however you define activist. There's some activism that I think you and I agree is necessary when it's protecting the Constitution. And so it was a soundbite that sounded nice, but judges are not umpires. Judges are there because of their value set, their understanding of the law, the way they look at the Constitution. Look at this debate that went on the other day between Justice Souter and Justice Scalia. Is the Constitution a living document intended to be adapted to present-day needs, or should it be interpreted today the way we believe the framers who wrote it, wanted it to have been interpreted when they wrote it? These are profound issues, and they are affected by what judges think. A judge you and I admire, Benjamin Nathan Cardozo, once said, justice is determined by the personality of the judges. That sounds outrageous, but it's true. They're human beings. They bring their value set to the courtroom, and no one can deny that.
Which a lot of senators deny. Constantly. And,
Yes.
I mean, Cardozo was a brilliant jurist, a member of the Supreme Court, wrote this great book we all read in law school, The Nature of the Judicial Process.
Right.
But they still, a lot of senators still think it's just an automatic process, you know, just like umpires.
Well, if that were the case, then we could have an instant replay. We wouldn't need the human factor in there.
And why do they differ so much then?
Precisely, precisely. Look,
Right.
there are justices who believe that the Constitution means what it says, and guarantees are guarantees. There are others who say, well, there's wiggle room for everything.
Yeah. Okay. Line number 7, your body is your temple. And you go into issues of the war on drugs and what you call the food police. You criticize Roe versus Wade, but you don't give your opinion on abortion in that area. At least I didn't see it in the book. What's your stand on that?
Ralph, I am a pre-Vatican II Catholic, so I am absolutely opposed to abortion under all circumstances. This is a philosophical judgment. We cannot determine medically precisely when life begins. I give the benefit of the doubt at the beginning. So this book is not about my philosophy of when life begins, but I am clearly on record as being in the pro-life camp, forcefully and vehemently in the pro-life camp. Putting that aside, there is no right to an abortion in the Constitution. There's a right to privacy, but there's not a right to commit a crime under the right to privacy.
So what's the role of the government with the women's reproductive rights?
In my opinion, the fetus is a separate individual, and that individual has rights and can command the protection of the government just as you and I. And for that reason, there could be no abortion absent due process, which would be inconceivable to demonstrate that the fetus is somehow culpable of being executed.
Well, this, you know, the libertarian view usually is that the government shouldn't have a right to tell a woman either to have a child or not to have a child.
You are correct in that, and I part ways with a lot of my sisters and brothers who are libertarians on that issue. There is a growing pro-life group among libertarians, but many true North libertarians, of which I am one, do not recognize the fetus as an independent being and say it's the obligation of the government to keep hands off. Most of this chapter basically says in a society where a woman can execute the baby in the womb, how could a person not put whatever chemical they want into their body as long as by doing that no one else is harmed?
Well, the interesting thing about this is that you're pretty consistent, according to what most people think libertarianism is, when it comes to the war on drugs. Marijuana, heroin, cocaine, what would you do?
None of the government's business. A person has the freedom of choice. They have the right to be wrong. They have the right to impair their body. They have the right to utilize whatever substance they want in the privacy of their home as long as it doesn't hurt anyone. If it hurts a child in the home because a parent is taking it, the government can intercede. If someone gets behind a piece of heavy machinery like a train or a plane or a car under the influence of drugs, it's the same thing as driving under the influence of alcohol. It's the government's job to protect innocence from persons in that situation. But if a person utilizes recreational drugs exclusively in their own home and no one is harmed thereby, it is their choice and it is none of the government's business. If I own my own body, I can decide what to put in that body. The government can't make that decision for me.
What if the woman has a fetus in her?
That could impair the fetus. And as you know, there are cases of women, published opinions, where women have taken recreational drugs and it has affected the fetus, or the state has argued it has affected the fetus, and the woman post-birth of the child has been prosecuted. I'm not in favor of police telling us what to do with our bodies. I'm not in favor of the mayor of New York saying there's too much salt on restaurant tables. This nanny state will lead to the loss of all freedom. But if the fetus is a separate human being, and I believe it is, then that human being is the most helpless in the world, totally dependent upon the mother in whose womb she or he resides, and can command the protection of the state.
Let's take your phrase, food police. 7,000 Americans died because of contaminated food. A lot of it is contaminated seafood. Some of it is coming in from China, for example, contaminated. You really, when you go to a restaurant, you don't have the senses to detect a lot of this.
Right.
You can't taste, smell, or see botulism, for example. What role would you have for the government in regulating food for safety?
I would have no role in the government for regulating food for safety, because the government is the most inefficient regulator of private behavior we have. It is heavy-handed, it is thoughtless, it breaks its own laws, it is inefficient, and it adds to the cost of everything.
We'll get to that abstraction in a moment. The key is 7,000 die, 70,000 are sick, and many, many thousands of those are hospitalized. How do you deal with that?
Because we rely on the government to do what it can't do.
Well, who can do it?
Well, there should be some private enterprise. There should be some entity, perhaps paid by the insurance companies that insure the restaurants, who don't want people to get sick, because they'd be on the hook if somebody sued.
Why aren't they doing that now?
Because they rely on the government. When you and I go into a restaurant, as we may very well do when this wonderful interview is over, we don't think twice about the cheeseburger we're about to eat, because we assume that some bureaucrat, barely educated, ignorant in the law, nevertheless has walked in the kitchen and performed some kind of a test on the food. That doesn't work.
Well, actually, it has worked. Food has been recalled, food has been condemned, lives have been saved.
Well, there's a moral obligation on the part of the preparer of the food and the distributor of the food, not to put something contaminated into the food chain, so to speak.
Or how about the right to sue? If you're contaminated, you get sick, you sue the food company or the restaurant.
Absolutely.
You don't believe in restricting tort law?
Absolutely. I am against the mantra of tort reformers, because tort has resulted in an uplifting of human society. You remember a famous New Jersey Supreme Court case, Henningsen versus Bloomfield Motors. Every law student in the United States studies this. As a result of that case, the automobile manufacturers started making brakes more safely, because Mrs. Henningsen was severely injured by a car sold by Bloomfield Motors at a time when there was no warranty of merchantability for the brakes. How did that happen? Because a courageous lawyer brought a lawsuit in a court system that had rejected all those, and this one they accepted.
So that's contrary. Your position against so-called tort reform, which I call tort deform, you take away people's rights, is quite contrary to the dogma of a lot of Republicans.
It is. It's against the dogma of conservative Republicans, but it's not against the dogma of those of us who believe the individual is greater than the state and that our rights are natural. And one of the legitimate functions of the government, even to this true North libertarian, is to provide a forum to seek the redress of your grievances, which we call the court system.
As a matter of fact, the studies show that over 90% of wrongful injury never reaches a lawyer. You know, they don't even get to the courts. So what do you think of this mantra that tries to justify taking away people's access to court by saying we're a litigious society? Where's the evidence for that?
I think a lot of my friends and colleagues will recoil at the following statement. I think that because a lot of trial lawyers tend to be liberal Democrats, I don't know why, the conservative Republicans resist them. Wait until one of them is injured and they need a trial lawyer to go after the big business or even the small shop owner that had a banana peel on his floor and caused that injury. The right to sue is one of the great protected natural rights going back to the Magna Carta, and the government should not interfere with that.
You're getting no argument from me on that. Next lie, this is getting into more controversial depth here. The next lie I want to discuss with you is lie 12, which says, quote, everyone is innocent until proved guilty, unquote. You say that's a lie. Why?
Because the government has enacted legislation which has so hampered defendants, it has so treated them as if they were guilty before proof. It has made it so difficult, before trial, it has made it so difficult for them to defend themselves that the government acts as if a person is guilty merely on the basis of an accusation or an allegation. The government breaks its own laws when it leaks grand jury material in order to affect the jury pool, the people from whom the jury will come, so that they will conclude that this person must be guilty. Look at all the stuff that's in the newspapers about them. The government seizes assets from individuals merely because they've been indicted, so they don't have the resources with which to hire counsel to defend themselves. The government persuades judges that this guy has a passport, therefore he might flee, so you can't let him be free. He has to actually prepare for his trial in a cell with 15 other people, 14 of whom might want to kill him, and in which there's no peace of mind or opportunity to deal with his client, to deal with his lawyer, which violates other rights. The seizure of property, post-indictment and pre-conviction, is one of the great modern travesties of our criminal justice system, because the standard of proof for seizure is less than proof beyond a reasonable doubt. Prosecutors have persuaded judges, you know, we're probably going to win this case. Let's take his money now so he can't dissipate it. Then he has to have a public defender instead of Ralph Nader or some really great lawyer to defend him.
What about the more serious violations of habeas corpus? You know, after 9/11, Bush rounded up thousands of Americans, many of them Muslim Americans, Arab Americans, and they were thrown in jail without charges. They didn't have lawyers. Some of them were pretty mistreated in New York City. And they were all released eventually.
Correct.
What is that what you mean also about throwing people in jail without charges, violating habeas corpus?
That is so obviously a violation of the natural law, the natural right to be brought before a neutral arbiter within moments of the government taking your freedom away from you. And the Constitution itself, as the Supreme Court in the Boumediene case pretty much said, wherever the government goes, the Constitution goes with it, and wherever the Constitution goes are the rights that the Constitution has to guarantee, and habeas corpus cannot be suspended by the president ever. It can only be suspended by the Congress in times of rebellion, which In re Milligan says, meaning rebellion of such magnitude that judges can't get into their courthouses. That has not happened in American history. So what President Bush did with the suspension of habeas corpus, with the whole concept of Guantanamo Bay, with the whole idea that he could avoid and evade federal laws, treaties, federal judges, and the Constitution, was blatantly unconstitutional and in some cases criminal.
What's the sanction for President Bush and Vice
Unfortunately,
President
there has
Cheney?
been no sanction except what history will say about them.
What should be the sanction?
They should have been indicted. They absolutely should have been indicted for torturing, for spying, for arresting without warrant. I'd like to say they should be indicted for lying, but believe it or not, unless you're under oath, lying is not a crime, at least not an indictable crime. It's a moral crime.
So you think George W. Bush and Dick Cheney should, even though they've left office, they haven't escaped the criminal laws, they should be indicted and prosecuted?
The evidence in this book and in others, our colleague, the great Vincent Bugliosi, has amassed an incredible amount of evidence. The purpose of this book was not to amass that evidence, but I do discuss it. Is overwhelming when you compare it to the level of evidence required for a normal indictment. That George W. Bush, as president, and Dick Cheney, as vice president, participated in criminal conspiracies to violate the federal law and the guaranteed civil liberties of hundreds, maybe thousands of human beings.
Is Obama still supervising torture?
As far as I know, yes. As far as I know, people are still undergoing rendition. We still have some of these black prisons, they call them. I don't know why that phrase is, but the intelligence community refers to it because they like to deny that it exists, like a black hole. And we still have people in Guantanamo Bay who are being kept without charge, without trial, and the president still claims the power to lock people up and throw away the key. Recently, this president claimed the power through his then Director of National Intelligence, Admiral Blair, who has since resigned, though I'm not sure he's left office yet, to kill Americans on foreign soil if the president thinks that they are engaged in acts of terrorism. That would be murder.
In other words, the president, and contrary to our separation of powers, the president becomes the prosecutor, the judge, the jury, and the executor.
In his own mind, yes. And what torments me, Ralph, is that there was no outrage when Admiral Blair said that. I don't know if President Bush did that, and I don't hold water for President Bush. But if he had said that, or if Admiral Hayden, President Bush's Director of National Security, had said that while President Bush was in office, our friends in the media would have gone over the top about it, and rightly so. Why did they not do so when President Obama's Director of National Security said that? Why do we believe that as we're sitting in a comfortable studio in Washington, D.C., somebody not far from here is pressing a button on a computer which dispatches a plastic drone to somewhere in Pakistan to kill an American? If the government believes an American committed a crime, arrest him, indict him, and follow due process. That's what the Constitution says.
Well, lie number 15 is we don't torture, which we've been talking about. And at the beginning, you say, on June 26, 2003, President George W. Bush asserted, quote, the United States is committed to a worldwide elimination of torture, and we're leading this fight by example, end quote. You continue. No surprise here, President Bush lied. The United States of America is not committed to the worldwide elimination of torture. Rather, under Bush, it, supported, facilitated, and directly engaged in torture. The United States has tortured people and will continue to torture so long as Americans overlook and excuse the crimes committed by our government and as long as Americans accept government deception on torture. Now, you say that torture violates U.S. law, like
Correct.
the War Crimes Act of 1996, which
Correct.
was passed under Clinton. It violates the U.S. Army Manual. It violates the U.S. Constitution. It violates the Geneva Convention. Where are the 1 million lawyers in this country, only a tiny number of which, including you, have spoken out? Aren't they supposed to be the sentinels for the rule of law, for probable cause, for due process?
They are.
How do you explain that?
I don't understand the reticence of lawyers to stand up for the rights of the innocent unless it's, forgive me for saying this, racial, because the innocents all happen to be young males, or for the most part in their 20s with dark skin. I hope that that's not the case, but it's the only rational conclusion that one can come to. Lawyers should be shouting from the rooftops. They should be filing lawsuit after lawsuit. They should be seeking indictment after indictment. If there's any line that could be drawn in the sand, it is that we don't torture. I believe it doesn't work. There's a lot of evidence in there that it doesn't work. Even if it does work, it is the most contrary thing to our values and our standards one could imagine. We simply don't do it. In this, I argue that George Bush made arguments that he didn't do it, but in fact did. And I quote a Deputy Assistant Secretary of Defense, Susan Crawford, who simply said, we tortured. We did, no matter what the president said.
That's right. It's right on
The evidence is overwhelming. Now Federal Judge Bybee, when he was Assistant Attorney General Bybee, wrote a horrific memorandum to the president telling him what he could get away with and what he couldn't. In the memorandum itself, he contradicts himself and admits that these techniques are a near occasion of death, which is one of the definitions of an act of torture.
Would you prosecute him? And would you prosecute John Yoo, who was his collaborator in the memos, the notorious memos justifying these war crimes?
Without question, I would. Unfortunately, the Justice Department, the present Justice Department, President Obama's Justice Department, has just issued some sort of a whitewash that these guys were just lawyers giving advice. There's a certain point beyond which a lawyer knows she or he cannot go when giving advice, especially when the entity to which you're giving advice has all the power and might of the President of the United States. They advised him to commit crimes. That advice is criminal.
And you say in your book, Mr. President and Attorney General Holder, what are you waiting for? And you're referring to President Obama.
I am, and I would ask him that if I had the opportunity. A lawyer who taught constitutional law at the University of Chicago, he knows these things.
You know, Michael Greco was head of the American Bar Association around 2005, and he and other lawyers, some of them who were in the national security agencies before they became private lawyers, sent 3 white papers to Bush asserting that in one area after another he's violating the Constitution. And that was the only really strong stand in writing by the American Bar Association, which has 400,000 members. What would you do to kickstart the American Bar Association and 1 million lawyers who are supposed to be officers of the court?
Well, I'm not a member of the American Bar Association, but these people should have filed lawsuits which require answers, which get before a federal judge and which give you tools which we call discovery tools. They allow you to find out what the defendant was doing and what the defendant was thinking. And if the defendant is the President of the United States and the courts wants to say, wait until he or she leaves office before we do this interrogation, then so be it. That time would be ripe, and the ripe would be now. My hat is off to Mr. Greco and what those folks did, but they barely scratched the surface of what they should have done and of what the tools of the law has given them to use.
In other words, really, the American people cannot rely, with a few exceptions, on 1 million American attorneys to uphold constitutional rights, civil liberties and civil rights, due process and probable cause, except in this narrow area, thanks to African American mobilization back in Martin Luther King time, where they do have legal staff and they do bring suits. But in the area of foreign policy, in the area of the so-called war on terror, in all these areas you discuss in your book, they're AWOL.
One of my prior books is called Dred Scott's Revenge, A Legal History of Race and Freedom in America. And every time I take the train past Baltimore, I think of the childhood stories of Justice Thurgood Marshall. Where is the Thurgood Marshall of today to challenge the government? He almost single-handedly overthrew Jim Crow because he walked into a courtroom with a white judge and a white jury and said, this is wrong and it's got to stop. And he prevailed. Yeah. That should happen today. There should be a Thurgood Marshall for civil liberties against war crimes out there today, and I want to meet that person.
It's interesting. It's often said the great advances in American jurisprudence do not start with judges and juries. They start with the advocate, the lawyer, who brings the case.
Yes, and you and I were both trained that way. Yeah. I taught law school for 11 years. The young people are still trained that way today.
Well, we're going to take a break, and when we come back...
Why do we have to stop?
No, we're coming back. We're going to take a break, and we're coming back, and I'm going to discuss lie number 14, which is really dynamite, quoting Franklin Delano Roosevelt, quote, "Your boys are not going to be sent to foreign wars." We'll be back.
Afterwards and several other C-SPAN programs are available for download as podcasts. More with Andrew Napolitano and Ralph Nader in a moment.
We've got 3 C-SPAN books for you: Abraham Lincoln, The Supreme Court, and Who's Buried in Grant's Tomb, each with a unique contemporary perspective and perhaps something new to you about Lincoln, the nation's highest court, and the gravesites and lives of America's presidents. To order, go to cspan.org/books.
Afterwards with Andrew Napolitano and Ralph Nader continues.
We're back with Mr. Napolitano. I want to discuss lie number 14, your boys are not going to be sent into any foreign wars, where you basically describe how the Constitution has been so flouted. The declaration of war doesn't really exist. It's been neutered by an abdication by Congress. Bruce Fein has written a lot about this, and he thinks that Congress has turned itself into an ink blot, and it is abdicating its constitutional duties and responsibilities to the White House, which centralizes power in the White House. Could you explain lie number 14?
I'm a great admirer of Bruce Fein's work, and he has pointed out in an academic and intellectual way the abdication of the Congress of its constitutional role of declaring war. The Congress did a couple things. In reaction to some of the things President Nixon did, it enacted the War Powers Act, which of course he vetoed, and then his veto was overridden. They thought they were enacting the War Powers Act in order to restrain the president. Like a lot of legislation, had the unintended consequence of unleashing the president. So under the federal law, the president of the United States could fight any war he wants for 180 days, mobilize all the human beings he wants and all the material he wants, and doesn't need the consent of anybody. That's a violation of the Constitution. A 180-day war is a war, no matter what you call it. The Constitution says only the president can declare war. After 9/11, President Bush did not ask for a declaration of war. He asked for something amorphous called the Authorization to Use Military Force, known by its initials, AUMF. And the Authorization to Use Military Force basically said to President Bush and his successors, go after anybody you want in the war on terror, use any means at your disposal. Well, that's an open-ended war. There's nobody to surrender. There's no target identified. Listen, I believe that FDR maneuvered the Japanese into attacking and killing innocent American sailors and soldiers on December 7th, 1941. But as a result of that, he got a declaration of war against 3 countries. And when those countries surrendered, he lost his war-making powers. President Bush never lost the powers given him by the Congress under the AUMF. President Obama inherited them, and as long as that monstrosity is on the books, every one of their successors will have this absolute power to wage any war they want, anywhere they want. That's not what the framers intended. That's not what the Constitution says.
And you'll apply that to the Vietnam War and Korean War and the Spanish-American War.
I will certainly do that. The Vietnam War was particularly egregious, as we know. And I was on the Princeton campus when you came to the campus to speak against the Vietnam War, and I was wearing a T-shirt that said "Bomb Hanoi," and I still came up and shook hands with you because my views were different at the time. But we now know that Lyndon Johnson and his staff, and perhaps some of the military folks around him, lied about, made up the Gulf of Tonkin incident in order to get not a declaration of war, but a similar Gulf of Tonkin resolution. Go ahead, Mr. President, destroy North Vietnam because they tried to bomb a ship, which we would later learn throughout history wasn't even there when it was supposedly bombed.
And it's Korea, which is considered a UN-approved police action. Was that enough?
No, that was not enough because the Constitution means what it says, Ralph. And when presidents, even with popular support, even in times of emergency, think that they can twist and torture and maneuver their way around the Constitution, that begins a slippery slope, and it is a precedent for other presidents to do the same thing. The most powerful weapon that the president has, after the power to prosecute somebody, is the power to wage war. The courts will interfere with a prosecution. The courts will never interfere with a war. Why? War is the health of the state. War lets the state regulate human behavior. War lets people surrender their liberties because they think they'll be kept safe. War lets the government raise taxes. And when the war is over, do the taxes go down? Do the liberties come back? Rarely, if ever.
Spanish-American War.
Well, I don't discuss the Spanish-American War in here, but we do know from history that the Spanish-American War was concocted by President McKinley because wartime presidents are powerful presidents, and the state is treated with grandiosity during a time of war.
Again, the ship that supposedly blew up in Havana Harbor.
You know, there's a lot of evidence that that ship was blown up by our own people. The Lusitania at World War I. Woodrow Wilson would not let warnings go out to Americans. Don't go on that ship because it's going to go through waters where there are German U-boats. The British begged him not to let Americans get on that ship. He turned a deaf ear because he wanted us in the war. We fought that war for 14 months, and there were 100,000 dead Americans.
You made a strong point of after every war, power is centralized, especially into the White House. Civil liberties are compromised. Fear is spread. In fact, you said the basis of government is fear by the people. So it isn't like we're idiosyncratic here in the United States. My reading of history is all societies and all governments lie to themselves.
Yes.
That's the way they have cohesion. That's the way they can mobilize and control people. That's the way they can live with their misdeeds, okay? So it's hard to find a single government in the world that hasn't got a rationalization for the violence it inflicts on other people.
Well, think about it. The same generation, in some cases the same human beings who wrote, "Congress shall make no law abridging the freedom of speech," also wrote the Alien and Sedition Acts, which made it a felony to put the government into disrepute by the use of your words. How could the same people do that? There's a lust, we all have a lot of lusts, called libido dominandi, the lust to dominate. And this draws people to government. It draws to government people that have this lust.
Which gets us right into your strong criticism of the Patriot Act and FISA, the so-called surveillance law, and what happened after 9/11. And lie 16 is the right of the people to be secure. Okay, so you want to elaborate that?
You know, the Patriot Act is the greatest abomination in American history, in my view, talking about legislative history, after the Alien and Sedition Acts. It was passed by overwhelming majorities in the Congress with no debate. Members of the House had 15 minutes to read it. I don't know if you've read it. I've read it 3 times. It takes about 20 hours to read.
It's 300 some pages.
Yeah, and it basically amends so many other statutes. You have to have the other statutes in front of you.
Yeah,
of course, it's impossible to.
And I'm just add to be fair to you. It's the right of the people to be secure in their persons, houses, papers, and effects shall not be violated. That's lie 16.
That's directly out of the Fourth Amendment. Why is there a Fourth Amendment? Because the King of England and the Parliament authorized British soldiers to write their own search warrants and enter our homes ostensibly looking for stamps, because you had to comply with the Stamp Act, which meant buy a stamp with the king's image on it and put it on every piece of paper in your house. Of course, while there, they would help themselves to wealth and alcohol and food and even the house itself. The Fourth Amendment was written to prevent that. And it says clearly, if the government wants to cross your threshold, it can only do so with a search warrant issued by a judge on probable cause. The Patriot Act allows federal agents to write their own search warrants and makes it a felony for the recipient of the search warrant to tell anyone, a spouse in the home, a priest in the confessional, a lawyer in the lawyer's office, a librarian, we can tell that story, even a federal judge in a courtroom. You can't answer truthfully under oath if you've received one of these self-written search warrants without, on its face, violating the Patriot Act. So this violates the Fourth Amendment, violates the First Amendment, was passed with no debate, overwhelmingly approved and signed with glee by a president who took an oath to uphold the Constitution. In reality, he assaulted it.
Post 9/11 panic in the Congress.
Correct. Correct. And President Obama has done the same thing. And again, without fanfare and without notice from our friends in the media. Most Americans don't even know that in 2009, after he had been in office for 6 months, he signed an extension of the Patriot Act with no debate, with no warnings. There are libertarians who vote against it. There are civil liberties people who vote against it. There are conservatives and liberals who vote against it. But people are afraid to oppose it because they accept this myth. If you give the government the power, it will keep us safe. It doesn't keep us safe, and it doesn't keep us free when we give the government our liberties.
How would you react to this statement? We're 2 or 3 major terrorist strikes away from a police state.
I fear that the statement is true. I fear that the American public, like generations before us, will accept the nonsense, and it is nonsense, that if we give up our liberties, the government will keep us safe. Meaning a police state could only happen here with public approval, and there would be public approval. President Bush argued, President Obama argued, articulately, their first job is to keep us safe. They are wrong. Their first job is to keep us free.
Quote Benjamin Franklin.
Those who would give up essential liberty in order to obtain a little temporary safety deserve neither liberty nor safety. If the president keeps us safe but unfree, he is not doing his job, and he is violating his oath.
Yeah, people in some prisons are safe.
Correct.
But they're not free. You're pretty hard on George Washington and Abraham Lincoln. For those in the audience who have not been exposed to Mr. Napolitano, let me say this. I have rarely met anybody who censors himself less. I'm going to challenge you.
Is that a good thing that I don't censor myself, or a bad thing?
I'm going to be challenging you with a checklist in a minute to see how far you'll go. But you talked about George Washington as a slave owner, and a very active slave owner.
Yes.
And
the Pennsylvania story.
Yeah, the Pennsylvania story. I mean, you said, quote, Washington punished his slaves by whipping or selling them, divided their families so they can work more efficiently, and provided them with as little means as tolerable. He also raffled off the slaves of those bankrupt slave holders who owed him money. Washington's most gruesome act as a slave owner came in 1784, 5 years before he became president. What was that?
He had the teeth of some of his slaves removed and implanted in his own mouth. He had the toes of some of his slaves cut off. There was no anesthesia at the time, so that they couldn't escape, so that they couldn't run away. And then when the capital of the country was in Philadelphia, and the state of Pennsylvania had said all slaves in the state shall be forthwith set free after 6 months, he and Martha rotated the slaves through from Mount Vernon in Virginia up to Pennsylvania so that they were rotated out before the end of 6 months, so he never had to set them free. This is the President of the United States and his wife engaged in a conspiracy and actively frustrating and violating the Pennsylvania law. Of course, they weren't prosecuted because half the country accepted slavery at the time.
It was legal. Slavery was legal.
Not in Pennsylvania.
And not under natural law, as you point out. You're also very critical of Lincoln, his hypocrisy. You know, the usual historians say, look, these were other times. You have to forgive them this. They at least helped create a constitution with a Bill of Rights. You're more merciless on Lincoln, who you called the tyrant. Could you describe his back and forth with the border states and his position on slavery and what the real cause, you believe, of the Civil War was?
Question. Did the Emancipation Proclamation free the slaves? Answer. It established and permitted slavery in the border states. You really have to read the document before you can understand that. Question. Was Abraham Lincoln interested in freeing the slaves? No. Abraham Lincoln said, I don't care if we have slaves or not. I just have to keep these southern states in the government because my job is to keep the country together because we don't have an income tax. And if we don't collect duties from the ports, and most of them are in the southern states, we can't have a federal government if that money is not coming in. Look, Lincoln arrested 3 3,000 journalists and publishers and editors in the North. These are not guys with guns shooting at federal soldiers. These are people arrested because of their words, because of what they said about the war. And he had them tried before military tribunals, every one of which was invalidated after Lincoln's death by a Supreme Court that he had just appointed that said the Constitution exists in good times and in bad. When the legislature of Maryland was about to enact legislation he didn't like, he sent troops to arrest every single legislator. He argued against the right to secession, but he caused West Virginia to secede from Virginia so we could have 2 more senators in the Senate and more representatives in the House of Representatives. He was the most tyrannical, most disingenuous, least faithful to the Constitution president we've had in American history. His troops burnt courthouses, raped women, robbed banks, killed civilians on a large scale for the first time in the history of the world, all in the name of a defensive war.
And you say it was the prime cause, was not slavery?
In my view, the prime cause was Lincoln's fear that the government would collapse if it didn't have economic activity from the South, particularly duties and excise taxes collected at every port from Wilmington to Houston. There were only 3 other ports in the country: Boston, Philadelphia, and New York. All the others were in the South. They lost 75%, or were due to lose 75% of the income from those ports.
And you mentioned states' rights in your book, too.
States' rights is a difficult argument to make because
on the Civil War.
On the Civil War, of course, because 8 of the states believed that they had the power to suspend the free will of individuals on the basis of their color. An abominable, condemnable, horrific state of affairs about which I wrote in Dred Scott's Revenge, but not something Lincoln was interested in eradicating. If he was, why would he have said to the border states and to New Orleans, "You can keep slavery," which is what he said in the so-called Emancipation Proclamation?
Well, of course, a lot of Lincoln's apologists is, he was in the Civil War. His top priority was preserving the Union, and he would do anything to preserve the Union.
Even kill innocents. I mean, if the Constitution prohibits anything, it prohibits executing people without due process.
Do you think we would have lost the Union if he performed with due process and more humane?
I think slavery would have died a natural death, as it did in Great Britain and Portugal and Brazil and France and Puerto Rico, and we would have stayed as a confederation of some sort.
Okay, now I'm going to give you, it's not a Letterman top 10.
All right.
But it may be a top 20.
I'm sure it's more thoughtful than the Letterman.
So we want really fast answers. Should corporations be able to patent life forms, genetic engineering?
No.
Okay. There's a 5-4 decision in the Supreme Court that said that was okay. Is the World Trade Organization and NAFTA a impermissible or unconstitutional violation of our sovereignty?
No.
You don't think that delegating to tribunals in Geneva, major decision.
Okay, the delegation aspect is, I agree with you. Okay. But the ability to trade with foreign countries because the product is cheaper is my natural right to buy a cheaper good.
Right, but on the international governance parts where they bypass our courts and they bypass our legislation.
Absolutely unconstitutional.
And yet there seems to be no ability to challenge it in the courts. What is your view on standing to sue? You think the federal taxpayers should have full standing to sue?
Yes, I think standing is judge-made law because they wanted to stop the cascade of litigation. The concept of standing, the right of an individual to force a judge or jury to hear a case, has been so limited by judges because they don't want to have to work too hard. They've made it next to impossible to challenge what the federal government has done unless your ox is being gored, unless they're coming after you in some unique, discreet way. Do you remember Goldwater versus Carter? Barry Goldwater trying to prevent the enforcement of a treaty signed by Jimmy Carter, which gave the Panama Canal back to Panama. If a senator doesn't have standing, who does?
So basically, they've shut the people out of the court. So no matter what corruption or waste in federal budgets, no matter the degree they violate the law, it's only the Attorney General that really has standing.
And who's the Attorney General? Somebody appointed by the President.
Right. Military budget, big, wasteful, should be cut back.
Utterly wasteful. Do we need 900 permanent military installations around the world in order to keep us safe? Absolutely not.
You think America is an empire?
Yes, I do. I think America has been an empire since the days of Teddy Roosevelt, a consciously driven empire by virtually every president since him.
Let's take the violation of international law. You think the U.S. chronically violates international law?
I believe that I've documented much of it in the book.
You think Israel violates international law?
Yes, I do.
And the takeover of the ship, was that a violation of international law?
It was an act of piracy. It was a violation of international law that will probably never be redressed in any court.
And do you agree with Franklin Delano Roosevelt, who said in 1938 to Congress, whenever government is taken over by private economic power, that's fascism? And you know Mussolini's thesis on this.
Of course I do know Mussolini's thesis. Fascism, in my view, is private ownership and government control, sort of the flip side of what FDR argued about. But when government and private enterprise are in bed with each other like that, whichever of the two is pressing the buttons, that's fascism.
Okay, so how do you define, in that context, the Wall Street bailout by the U.S. government after excessive speculation and draining trillions of dollars of worker funds and mutual funds?
It was taking from the poor and taking from the rich and giving to the super rich that were the government's friends. It was absolutely unconstitutional. TARP was unconstitutional. The Bush stimulus packages were unconstitutional. The Obama stimulus packages were unconstitutional. And as you just pointed out, nobody has standing to challenge them. Even members of Congress, let's take TARP, who were told, TARP stands for a Toxic Asset Repurchase Program. The government was going to purchase toxic mortgages, toxic paper, mortgages that were underperforming, and toxic assets, homes before people were going to be foreclosed. It didn't purchase any. It just gave the money to the Treasury Secretary's rich banker friends. It was an act of fraud perpetrated on the Congress, and nobody in the Congress did anything about it.
How about the two-party duopoly? You have in your book a brief reference to third-party rights and third-party and independent candidates.
I believe we have a one-party system in this country. It is the big government party. It has a Republican wing that likes war and deficits and assaults on civil liberties. It has a Democratic wing that likes taxes and welfare and assaults on civil liberty and assaults on commercial liberties.
You think it's also a big business party?
I do think it's a big business party. Before the Civil War, people went to Washington concerned about and boasting about liberty, human freedom, freedom from the government. Since that time, people go to Washington boasting about how I'm going to use the government to make your life better, whether it's authorized by the Constitution or not.
As you know, there are all kinds of state ballot access laws that make it very difficult, not in New Jersey, your state, but in other states, very difficult for third-party candidates independent, just to get on the ballot. They're harassed. Their petitioners are harassed. Partisan judges make outrageous decisions, and the documentation of that is my former campaign manager, Teresa Amato, who wrote a book called Grand Illusion, The Myth of Voter Choice and the Two-Party Tyranny.
You are the classic victim of that.
What would you do with ballot access laws? In the early 19th century, there were laws in the states that said you can get on the ballot if you print the ballot. I mean, it was much easier in the 19th century, so it had more variety of views.
Right.
What would you do with
Well, it would depend on who I was in your scenario. Can the feds change this? No, this is a state issue, but the states are violating people's natural rights. Your right to go to New Jersey or to go to California and say, I want to be president, and here's why, is violated by the vested interests in the legislature that wrote laws that prevent you from doing that because they don't agree with what you say and because they can't control you. And I don't mean you hypothetically. I mean you, Ralph Nader.
You would agree with the adage that I created years ago, dissent is the mother of assent?
Yes, I would. I would also agree with what our predecessor at Princeton once said, Norman Thomas. I am not the champion of lost causes. I am the champion of causes not yet won.
I can adhere to that. Speaking of adherence, what do you think of corporate coercion in standard form contracts, where they basically have compulsory arbitration, keeping you from the courts, and they don't compete over it? Allstate and State Farm don't compete. Bank of America, Citigroup don't compete. And they're getting extremely draconian in their one-sided coercions. What do you think of that?
Well, I mean, the courts have a principle. This is called a contract of adhesion. Take it or leave it. You can't. We're not going to negotiate with you. But if you're suing under the contract of adhesion, any ambiguity is construed against the preparer of it.
Yeah.
The lawyers know that,
Yeah.
and they have prepared it so there can be no ambiguity. Look, that might be some sort of a violation of natural rights. I would like to think that another insurance company would come into existence that would let me freely negotiate with them, that would put these guys that aren't interested in natural law out of business.
You know, we have a project on this, which really the freedom of contract has been destroyed.
Yes, it
Whether
has.
you have insurance or hospital or health insurance or auto insurance or bank deposit card with the fine print or installment loans.
Suppose I'm British Petroleum and I have a contract with my shareholders to give them a certain dividend. Who is the government to come in and say, don't pay the dividend this month? They're violating freedom of contract.
From that end. But in terms of the corporations coercing consumers, beyond the doctrine of unconscionability, which once in a while you can go to a court and say, hey, my landlord lease has a clause in it that says, the minute I sign the lease, I confess to any judgment.
Correct.
In the future.
Correct.
And that's considered unconscionable. Do you think, is that enough? Are the
No.
courts alert enough? Do we need legislation prohibiting such draconian one-sided coercion?
We need judges courageous enough, lawyers courageous enough to get those things changed.
Well, let me go on to a couple of other things. Corporation as a person. This takes animism to a high level in our complex society. Santa Clara case, late 1880s, the Supreme Court rendered in favor of the railroad in a tax case. But not even in the opinion. In the head notes, it was declared by the scribe, who was a former head of a railroad in the East, that the railroad is a person for purposes of equal protection under the 14th Amendment.
This is one of the most bizarre cases in American history because the case doesn't say what we have all been taught it says, but somebody's interpretation of it. As you say, the clerk responsible for recording it put in a summary preceding it saying this is what it said, and generations of lawyers, judges, and law professors read just the summary.
Now, should corporations have all the constitutional rights of real human beings, the artificial entity itself?
Well, the entity should have certain rights of privacy and certain rights of due process. So I don't know
what
if it
rights
should
shouldn't have?
Well, I haven't thought that through, but I don't want the government to be able to rape corporations. I want the government to have to follow due process.
Right.
So it should have the right to privacy. It should have the right to own and use its property. And if the government doesn't like the way the property is being used, it can't just legislate it away. It has to challenge it before a jury, just like if they don't like what you're doing in your backyard.
We're running out of time. In its totality, this book, these lies are dominant now. They're the dominant ideology.
They are.
And they are taught to our children in our schools. And they are bandied about on talk shows and talk radio. Is Fox immune from that in their fair and balanced treatment? Do they parrot these lies?
You know, Fox, where I've been happily employed for the past 12 years, has people who deliver the news, in my view, very fair and balanced, and people who formulate opinion. I am in the latter category of formulating opinion. I am the Ayn Rand, though I'm a male and a Catholic and I don't smoke. I'm the Ayn Rand of Fox News. I also have my colleagues Alan Colmes and Geraldo Rivera, and I have my colleagues Glenn Beck and Sean Hannity and Bill O'Reilly. So we're really all across the board. None of the names that I've just given you are in the business of delivering the news fair and balanced. We have other colleagues who do that. Our job is to probe and provoke and prod and get people to debate about freedom.
And what about the war on terror? What do you think of that phrase, and what do you think of that foreign policy?
I think that terror is a means. It's the same means that George Washington used to free us from the Parliament and the King of England. And I think in the name of that phrase, a multitude of constitutional sins have been committed, many of which I outlined in A Nation of Sheep, and some of which I outlined in Lies the Government Told You.
Do you think radio and TV stations should pay a license fee for using the public airways to the Federal Communications Commission instead of getting it free and deciding 24 hours a day who says what and who doesn't?
I would prefer that the free market entered the picture rather than government regulation, because I fear government regulation is going to put me out of business if my challenges to it get too successful.
This is just a license fee. Like the biggest TV station in New York pays less to the FCC than you pay to the Motor Vehicle Department for your driver's license.
Oh, That's above my pay grade, how much they pay.
No, I mean, would you have a license?
I am basically against government regulating the free market.
But public airways are public property.
I understand that.
Yeah.
I understand that. I don't know why there is a license fee if it's so little.
Right.
Is it to assure
zero? It's zero.
Is it to assure the financial the financial wherewithal of the person getting that part of the broadband so that they won't go out of business, or is it to enrich the bureaucrats so they have more cash to spend, or is it to keep the little guys out? I don't know.
It's free. Yeah. So to be continued. I want to thank you very much, Mr. Napolitano, and I look forward to your new program. And I think that if you raise these issues on your new program, you're going to have a very big audience. Thank you very much.
Pleasure, Ralph Nader.
Bruce Watson recalled.